So let's talk now for a moment about what the EU AI Act calls post-market monitoring. And we'll actually start with Article 72, which talks about an obligation on providers of an AI system to have a post-market monitoring system in place that is collecting and analyzing data about the AI system throughout the system's lifetime and having a plan in place that allows them to follow this and to report on it where necessary. This phraseology is really interesting. Post-market monitoring is a concept that comes up in some other regulated industries and in the US in particular in pharmaceuticals. So if in the US, the FDA approves a prescription drug as reasonably safe and effective, and there's a long process for getting that approval if you're a drug manufacturer. And then after that drug is out on the market, you've done some clinical trials and you've had to have done some human trials, so you have some pretty good scientific idea of how safe and effective the drug is, but you never know for sure until it's actually out in the general population and being used over time. There are often things that come up that weren't necessarily disclosed in the clinical trials. And so you want to, and you've got a systemic risk, right? A systemic health and safety risk if there's a prescription drug that's having some seriously unanticipated side effects. And so that might result in different instructions being given to providers. There might be interactions you have to be careful about. It might even result in a drug being removed from approval from the stream of commerce. So that idea of post-market monitoring for regulated industries that prevent systemic risk is a sort of common idea, and the EU here in the AI Act is applying it to AI. All right, and so the provider, the entity that is creating the model, has an obligation to maintain this post-market monitoring system. If we jump up to paragraph 79 for a minute, we'll see that it specifies a procedure at the national level for dealing with AI systems presenting a risk. So if an AI system is defined to present a risk, then remember that each member state under the EU AI Act is going to have a market surveillance authority, right? So a national authority that is responsible for AI. Each member state has one, and then there's an EU-wide authority. So these national authorities, in this process of market surveillance, right, of this kind of program, this post-marketing program, for example, that the provider has to maintain, determines that there's a risk. Then there's different measures that market surveillance authority might take. So recall that I used the example in the US of the FDA and post-market monitoring of a drug. And you could require that new instructions be given because there's an interaction that wasn't anticipated. You might find that there was some batch of the drug that has like a manufacturing problem, like a purity problem. You might have to recall that batch. You might find that that the use has to be suspended, so some additional tests can be done. You might find that actually the thing has turned out to be relatively rare, but has turned out to be such a problem that it has to be withdrawn from the market. So all of those sorts of things, similarly, right, are potential options for the Market Surveillance Authority with respect to AI under the EU AI Act. So notice the theme: the EU is viewing AI as something that could present these kind of system-wide, right, even population-wide kind of senses of risk that has to be watched carefully by the government authorities. So we see this reference in Article 79 to a product presenting a risk, and we might say, of course AI presents a risk, otherwise we wouldn't be regulating it. And so we need to know more specifically what the legal definition of a product presenting a risk is. And to do that, we need to look at another EU regulation. And this regulation deals with EU market surveillance authorities generally for various kinds of products that are subject to safety requirements within the EU. So that might have some approval requirements to be put onto the market, and then that will have ongoing market surveillance and post-market surveillance kind of requirements. And when we look at that regulation, we can see the definition of product presenting a risk. And so notice it talks about potential to affect health and safety in general or in various kinds of settings. To a degree which goes beyond that considered reasonable or acceptable in relation to the intended purpose or normal or reasonably foreseeable conditions of use of the product, including duration and installation maintenance requirements. Now, when you read that, it sounds very much like a product liability standard, a negligence-based, right, a reasonableness-based product liability standard. And indeed, that's the kind of standard it is. So it really doesn't give us a whole lot of specificity. We might understand what this means in relation to, like, let's say, automobiles or lawnmowers, right? A classic product liability case, the blade of the lawnmower breaks and a piece of it flies into somebody's eye. So we might know it's a dangerous thing. It's got a blade. It's got to cut the grass. But, how do you have to engineer the blade? What kind of safety flange do you have to have over the blade? Things like that. Very hard to know how this kind of thing is going to apply in the AI context. We are later in the semester going to look at product liability in a little more detail in relation to AI. Interestingly, the EU had proposed a product liability enhancement or amendment that would be specific to AI, and that was recently withdrawn. We'll talk more about that when we get to it, but I think very hard to know exactly what this means, but there's some kind of reasonableness requirement that relates to what a product presenting a risk for an AI system is. Now let's jump back to Article 26 and let's talk about the obligations of deployers of high-risk AI systems. So we've talked before about what high risk means in the context of the EU AI Act. A deployer, remember, is the entity that is actually making use of the system, whether it's internally in its own operations or whether it's putting the system out as part of some other product that it's selling to the product, right? So we have the developer who has created the model. We have the deployer is using the model. We might in between have a distributor who is sitting in between the deployer and the developer. So we have some things we've seen before, the making sure that it operates in accordance with the instructions for use, which we looked at that idea of instructions for use in terms of transparency and fairness and the like last week. Making sure there's human oversight. We talked about human oversight also a bit last week. But we want to focus on this week on this paragraph 5, which is this obligation to monitor. So the deployer, the developer has an obligation to have a post-market monitoring system in place. And there is an obligation also on the deployer to do monitoring, right? And the deployer has an obligation if it has a reason to think, a reason to believe that the high-risk system may result in presenting a risk as defined, as we just looked at that definition, right? So it's obviously it's high risk, it's defined as high risk, but is that unreasonable in relation to what the system is meant to do, whatever that might mean? And if the deployer determines that, it must, without undue delay, inform the provider or distributor and inform the relevant market surveillance authority and suspend the use of the system. So without undue delay, a notification and a suspension of the system obligation. Now notice there's a further obligation if the deployer has identified a serious incident, then they must immediately inform the provider, importer, distributor, and relevant market surveillance authority. So we've got a whole bunch of ambiguities here. What does a reason to consider that it might present a risk, where risk is defined as something unreasonable beyond what high risk already means? And then what does without undue delay mean? And then what does identifying an incident mean beyond simply having reason to consider that there might be presenting a risk? And in that case, having an obligation to immediately inform, and by the way, take the product out of service. These are some really potentially heavy and unclear obligations. As we talked about earlier in this video, the kinds of threats and the kinds of mitigations. What does reasonableness mean in a circumstance like this? I think this is another one of those areas where people who are critical of the EU AI Act say it's kind of too vague and too burdensome, and it's going to make it difficult for a deployer to actually put a system out there. But of course, advocates of it say, well, it's sort of the same kind of product liability like reasonableness requirement that we have on all sorts of other things like lawnmowers, and so maybe we should have it on AI as well.